An Introduction to the Science of Hadith by Ibn Salah al-Shahrazuri, 577 to 643 Hijri, the most influential work in the science of Hadith. Modern transmitters often indicate an instance of licensing which took place in the transmission of someone above the teacher who granted audition to them with the word from, an. So, when one of them is given audition by a teacher on the basis of his license from his teacher, he says, I recited to X from Y. If the student heard hadith from his teacher on the basis of his teacher's license from his teacher, and there was no audition between the student's teacher and his teacher, or the student is in doubt as to whether the transmission between his own teacher and his teacher was audition or merely licensing, application of the word from is reasonable. From may be applied with equal accuracy to both audition and licensing. God knows best. Be aware that the impermissibility of the unqualified application of he transmitted to us and he informed us to licensing is not negated by the licensor granting permission to apply it, as some teachers are wont to do. When granting a license to someone, they say, if the student wishes, he may say he transmitted to us, and if he wishes, he may say he informed us. So let that be known. Knowledge belongs to God, and he is blessed and exalted. 5. Correspondence, Muqaddimah. Correspondence is the fifth means of conveying and taking up hadith. It consists of a teacher sending some of his hadith in his own handwriting to an absent student, or the teacher writing them for him while he is present. Associated with this is the case when the teacher orders someone else to send the hadith from him to the student. This means of receiving hadith also takes two forms. One of them is correspondence without licensing. The second is correspondence coupled with licensing, with the teacher sending the hadith to the student and saying, I hereby license to you the material I wrote for you, or the material I sent to you, or some other expression of licensing similar to this. Many early and modern scholars, including Ayyub al-Sakhtiyani, Mansur ibn Mu'tamir, al-Layth ibn Sa'ad, permitted transmission by means of the first type of correspondence. And it is the case that when the teacher limits himself to the correspondence, that is, without licensing, a number of the Shafi'is subscribed to that opinion, and one of them said, his name being Abu Zafar as-Sam'ani, rated correspondence by itself stronger than licensing. Some legal theorists have also adopted this view. A number of others have rejected it. Among the Shafi'is, the judge Mawardi adopted the latter view and stated it unequivocally in his book Al-Hawi. The first doctrine is the correct one, and it is well known among the adherents of Hadith. Often in their hadith collections and writings, one finds them saying, X wrote to me. He said, Y transmitted to us, by which is meant correspondence. In their opinion, this is effective, and the hadith transmitted this way are connected. Correspondence itself contains a strong implication of licensing. Even if it is not explicitly coupled with licensing, it does not imply the substance of licensing. In the case of correspondence, it is enough that the student to whom the hadith is sent recognize the handwriting of the correspondent, even if there is no clear proof that it is actually his handwriting, or that his handwriting exists. There are some people who say one person's handwriting looks like another's, so it's not permissible to rely on that. That is unsatisfactory, because it is rare that one person's handwriting does resemble someone else's. The presumption is that one person's handwriting does not resemble anyone else's, and that there is no ambiguity about it. More than one of the learned and leading scholars of hadith, including Layth ibn Sa'ad and Mansur, subscribe to the doctrine that it is permissible to apply he transmitted to us and he informed us without qualification to transmission or correspondence, or transmission by correspondence. The preferred position is the doctrine of those who say, X wrote to me, he said Y transmitted to us, such and such. This is the correct view and the one appropriate for those possessing earnestness and probity. It would be equally valid if they had said, he informed me of it by correspondence, or in writing, or some other similar expression. Correspondence coupled with an explicit license is comparable to transference with licensing in terms of validity and efficacy. God knows best. 6. The sixth means of taking and conveying hadith is the declaration of the transmitter to the student that a particular hadith or a particular book in his audition or his transmission from X, merely saying that without going on to say, transmit it from me. I hereby give you permission to transmit it, or the like. In the eyes of many, this is a permissible way to relate and convey such material. This view was related from Ibn Jurayj and certain other transmitters of hadith, jurists, legal theorists, and Zahiris. The Shafi'i, Abu Nasr ibn Sabbagh, stated it unequivocally and preferred it. Abu al-Abbas ibn Walid bin Bakr al-Ghamri al-Maliki supported him in his book Al-Wajaza fi Tajweez al-Ijaza. The Judge Abu Muhammad ibn Khallad al-Ramhamurzi, the author of the book Al-Fasl Bayn al-Rawi wal-Wa'i, related that one of the Zahiris subscribed to this doctrine and argued for it. He added, if his teacher were to say to him, "This is my relation, but do not transmit it from me," he could still transmit it from him, just as it would not affect him if he were to hear a hadith from him and afterward he said, "Do not transmit it from me," or "I do not license it to you." The justification for the doctrine of these people is that they consider declaration of the transmitter to be equivalent to recitation to the teacher. When the student recites some of the teacher's hadith to him and the teacher silently assents that it is his transmission from X bin Y, it is also permissible for the student to transmit the hadith from him, even if he did not hear the hadith from his teacher's lips, and the teacher did not say to him, "Transmit it from me," or "I hereby grant you permission to relate it from me. God knows best." The preferred view is the one ascribed to a number of scholars of hadith and others to the effect that transmission on this basis is not permitted. The Shafi'i teacher Abu Hamid al-Tusi stated this unequivocally and did not mention any other possibility. This is because the material may be something the teacher heard and transmitted, but he does not grant permission for it to be transmitted from him, because he does not view its transmission as permissible on account of a defect he knows it to contain. His enunciation of the material is not present, nor anything equivalent to his enunciation of it. It is because of the enunciation of the reciter to him, while he is listening and silently assenting to it, that the transmitter from him who heard that may truthfully say, "He transmitted me to me," or "He informed us," even if the teacher did not grant him permission for that. Rather, in the case of declaration of the transmitter, and the transmitter is like a witness when he gives testimony outside of the courtroom regarding some matter, it is not valid for someone who heard it to bear witness regarding his testimony when he neither grants him permission to do so nor deputizes him to bear witness. This is one of the instances in which testifying in court and transmission are alike, because their substance unites them in that regard, even if they differ in other respects. Nevertheless, when the isnad is sound, the student must act in accordance with whatever his teacher mentions to him, even if his transmission from the teacher is not permitted. This is because the soundness of the hadith in themselves is sufficient for that, and God knows best. Number 7. Bequeathing books. Bequeathing books is the seventh of the categories of taking and receiving hadith. It consists of a transmitter upon his death or upon his departure for a journey bequeathing to someone a book which he relates. It is related that some of the forebears, God be pleased with them, permitted the legatee to transmit such material from the bequeathing transmitter on that basis. This is highly implausible. It is neither a lapse on the part of their scholars or interpreted to mean that they were referring to transmission by way of discovery, and this will be explained, God willing. One scholar argued for the validity of this form of transmission and likened it to declaration and transference, but that is not correct. There is a justification, which we mentioned, for the doctrine of those who permit transmission solely on the basis of declaration and transference. Nothing similar applies here, and bequeathing is not close to it either in that respect, and God knows best. Stay tuned.